Not listed. Relating to what? Bail. AB. Call it. Yes. What happened on last occasion? Why are you keeping this matter pen? You want to cancel a bail? We'll reject it. As simple as that. But is any benefit will you get keeping this matter pending in the board? On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed in the month of December 2023 on a date to be fixed by the registrar.
One more prayer. Appeal number 29.
Okay. When? 26th of September. Interim. Yes. 40. Yes, madam. Any interim?
27/9.
27.
I don't eat such things.
Okay. On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed 14 September. Yes. Bail matter hearing. Bail hearing. Yes, madam. 51. Yes.
Friday or Monday.
As per her attitude. Yes, Buddha. Yes. Yes. Okay. So what to do? He is not on interim. 20th. No interim. Okay. Item 50. Yes. Okay. It is submitted by Mr. Paul, learned counsel for the petitioner, that the petitioner has been arrested during the pendency of this present application. Accordingly, this present anticipatory bail application has become infractious. In that view of the matter, the present application stands closed, being infractious. The petitioner shall be at liberty to approve the appropriate forum for seeking regular bail, for not seeking regular. Item 15, can go? Yes. Item number 49, yes. Huh? Any interim? This 20, this fishery officer. This before any other bench without. No, not that. List this before any other bench. That will be listed tomorrow or day after. We'll call the register. Then you make a yeah. Item number? Yes. When? 26, no? Interim order, if any.
Motion BA, item number 1.
I'm sorry, that day, that late. Will respond that. Actually, what happened at the time of starting charges, they were in custody.
Huh.
I'm sorry.
Must be because that was the tick mark.
I'm sorry. What happened was I have received the WhatsApp,
No problem. Now you are in custody. Then you have not been granted bail today, till today. Now we'll have to see the scan copies. Are you having anything to?
WhatsApp,
Yes, give us, give us. If it's readable, we believe.
It's not the type of,
Let us see.
I think out. I'm sorry.
So this is a.
What happened at that point of time, he was arrested in another case also. He was in Vishwanath Sarili, the second place one of the forwarding report. And in the time, arrest was.
Just recall us what was the matter about.
He did, 364
Page 87.
You are Horan. Huh?
Three names there, Orange Banguba, Veru, Lahore, and Babel Khan. In the Vishwanath Sarili, there's very long for what. Order dated located before 8/2017, the bill only one is name will be located and the one other is.
Why don't you do one thing? These are certificate copies.
Certified to just I have got it in the WhatsApp.
Whatsoever you type it, give it to us day after tomorrow.
There's writing nothing just be possible. I typed many times. I myself tried this, but people. I have never given with a fight. I tried many times. Only two things are visible. The name, one name, and another logic will come out 20%. This logic will be.
Now why are you inside then?
Because of MD, after getting the bail notice, I was outside and.
Okay, according to this was the bail order on 4/8/2017.
After filing.
Okay, now NBOW was issued,
And I was
arrested on
There was order in the one 6
page
Page on,
18, page 13.
18. Under arrest for community on
Heard Mr. Munir, learned counsel for the petitioner, also heard Madam Substantial, additional public prosecution. The present application under section 439 of the Code of Criminal Procedure is filed for grant of regular bail to the petitioner who is in custody since 6/6/2023 and he was put under custody on the strength of a order and the strength of a non-bailable warrant of arrest issued by the learned trial court under its order dated.
One order is there.
Page. No, initially there was an issue or the original order, page 18. On the strength of 6/6/2023
That was
produced. Just a minute.
that order, sorry, that order I don't.
On the strength of a non-bailable warrant or warrant of arrest issued by the trial court as the petitioner failed to appear before the learned court below. Full stop. Failed. The learned counsel for the petitioner submits that why you are not present? Where is the explanation?
Page 4, 6.
It is submitted that people must be done. If I submit that though due to misunderstanding and communication gap with his lawyer, the petitioner failed to appear before the learned court, and accordingly the NBWA was issued and he is inside bail. Now, a specific stance has been taken that the petitioner shall appear on each and every date before the trial and will not fail. It will not fail and not ever evade the trial and participate in the trial. Full stop. Considering the above submission is as much as considering the fact that for a fair trial, petitioner should be to have a fair trial and to defend himself properly. At this stage, keeping him in custody shall not fulfill any object, as he has already undertook to present himself on each and every date when the matter is fixed for trial. So accordingly, the present application is allowed. Petitioner will be released on bail with 25,000 with a condition that he will appear so and so. The learned magistrate may, learned trial court may add additional condition for release of this.
I'm sorry, no problem.
22. I'm sorry, 2.
CD postmortem report. CD along with postmortem. 25th.
Item 3.
Yes. CD 21st.
Number 60. Supplementary list.
Yes, Swiss 55. With 55 will take it. What is that mistake? Correct in her copy. With initial. Yes, next.
Item 61.
Same with 50.
KB.
What is the FIR? Interim. No interim. CD. This is not your job. No interim.
Item 5.
And the petitioner supposed to also do the minimum of this petition to a final. Royal Almost 1 hour.
FIR is at page,
Page 9, actually,
you are Mr. Subhas.
Subhash Chudodar and police reported the apparently we are the family members of these two people. 9 petitions. There are Subhash Chudodar work there. Actually, for this is telling us to
Along with 5, 6 others.
allow the friends of this Subhash and these police. I have admitted this that they have made it for us.
Considering that petitioners are not named in the FIR. When? Interim when? City interim when? 25th.
So I will not specify this.
Oh, then no interim. Then no interim. Then no interim. City. No. Then you are involved. City. CD. You will also be arrested. Come on. I was not inclined, but thinking that they're not specifically named, but 2 others are arrested and who has beaten up like anything. This is not a case for interim. Yes, submit.
Only because these two people could not be offended by the police law. The police continuously visiting the house of this division of the and threatened that if they would not provide this division of law, they will be arrested. Accordingly, the police has been arrested. That is a severe amount. They are the all fathers, uncles, and other community members. Only because of this. If you doesn't get any single whisper in the city, kindly reject any whisper in matter.
Considering the nature of allegation and the allegation of serious injury, this court is of the view that petitioners, though not named in the FIR, however, a specific statement has been made that along with the accused person, 5, 6 other persons also involved in this case. And out of these 3 petitioners, already petitioner number 6 and 7 has been arrested. This court is not inclined to pass any interim order at this stage. Should be along with injury. 25th.
Item 62 of supplementary list.
Other is fine, but why there is some serious allegation against it?
I will only make one solution. Our para 30 minutes. Instead of this color victim minor, is also there at her place. She is residing with Mr. C today minor, and she is studying a physical science to minor para 13 minor. Her statement was well taken minor.
Where is the admission register? Where anything fees paid, anything?
Minor. If I am permitted, I will face tomorrow minor. Let me my question tomorrow. I will face everything.
This is
Studying a physical science or at 2 I will face minor or at 2 minor.
it's a case of interim, but only allegation what is disturbing us is that this may be case of suicide.
Yes.
But only thing is that there is a allegation against him that specifically stopped her to contact with the family. That is allegation.
So minor, that is not-
Listen to me. Otherwise, the family parents have not lost the affair. This has been lost by some other. So he requires an interim protection considering his status. He's a doctor, I think.
No, I can see manager area manager.
Okay.
Then
Then this course will not considered as only in because of interim. Somebody requires that is not. When it's from San Mario only. 19th. CD interim. Yes. That is mandatory within a week. Get recorded, give all these statements and give the documents in original. 21.
Item number 7. for motion.
Motion it. How many days? 6 months or 3 years? Huh? Okay. This is item number? Okay. Notice LCR. Steps within any private parties? No, not concerned. Madam accepts notice on behalf of all the respondents. IA, considering the nature of allegation, material available, and the period of sentence. The petitioner is allowed. Petitioner or petitioners? Petitioner, namely so and so, is allowed to remain on previous will. IA stands disposal.
Item 8.
Yes. Huh? Where is the affair? Huh? What is the name of the accused? Trial has commenced. A victim. Victim. Where is that? To appear till then NBW shall be heard. Huh? Therefore, we are not merit commenting any merit. Court will decide. NBW, huh? Court will decide. Appear before and on its own merit, till such determination, the NBW MP shall remain suspended. Yes. This NBW.
Bail hearing BA, item number 14.
Sheet is there, madam. Search sheet has been filed. Was illegal. It's a tribal by session. So says till committal to a trial court. Interim adversal court.
Item 15.
Session hall till committal, committal by the court and matter is placed before the trial court. Till then and files an application. Yes, next. Not received. Where is the affair?
Reflected on 10 page 10, but what is right to take the
When you were arrested,
Was arrested on 06/07/2023.
6, 7. How many days?
Today is 69 days.
What are the offenses registered?
384, 394, 420, 379.
Why 384 and 342?
Lordship, they have, the complainant said that when he was going to the road, the petitioner stopped him and to get a car. But you cannot attend the main road without any announcement. If they demanded money from me, then I could not give money.
This may be some higher purchase and all. Let him go. I'll register your objection. Huh? Considering the only length of detention. 50? How many days?
69 days.
69 days. Behind bars in 60 days, considering the length of detention. And also fact that those city was called for on last so many occasions that has not been produced. This court is of the view that no further custodial detention is required. Yes.
I know.
Your satisfaction of
No.
the basic fundamental. For that you everybody needs to CJM law,
16,
50,000. Charge sheet
My certificate case matter and the CGO matter.
under 302.
Minor. And here we have received, but the statement of the witness is not available. And then the status report is.
What is your name? Rahul Malla, Bharat Malla. Offense is registered under 30. But how can they see the order dated SDGM Gompur? Case record put up along with charge sheet submitted signed. So the case transferred to the court cell for disposal. How can magistrate do this? Huh? Last seen together.
Minor, they have fallen in the night matter, from the PME for the aspect, no matter.
I've seen it for injury, but where is the case diary?
Not minor, this is
What is the stage? Where from this case diary will come? How can magistrate take up this for disposal? Heard, it's a strange learned counsel for the petitioner. The present application is filed for under section 439 so Criminal Procedure Code 1979 for granting of regular bail to the petitioners, namely Rahul Malla and Sri Bharat Malla alias Moon, who have been arrested in connection with Hallam Police Station case number 46 of 2003 under section 302/34 IPC. Arrested on Diluno, arrested on 27/2023. This court the case diary of the aforesaid police station case along with the record of the trial court was called for. Though the record of the trial court in connection with PRC 225/23 is received, the case diary has not yet been received. Accordingly, the registry is directed to forthwith call the case diary of so case, our typical government case, so case in connection with GR case number 182/23 pending before the learned SDGM, JMFC, Kapur. The record of the learned magistrate reveals that by an order dated 30/8/2023, the learned SDGM within bracket M Kapur took up and transferred the case to itself for disposal. This court is of the view that the magistrate shall have no jurisdiction to dispose of or take up the trial in view of the charge sheet, in view of the fact that charge sheet being filed under section 302/34 IPC, which is also reflected in order dated 30/8/2023, passed in GR case number 182/23 corresponding to PRC 225/2023. The learned magistrate shall also the registry also call for a report of status report as well as the reason why and how a magistrate has transferred a case involving the allegation or commission of offense under section 302/34 to itself for trial. List this matter on, give a date before Puja, September. Before that, 18 will be too late, huh? 11th of October 2023. Registry to communicate and call for the communicate the order and call for the scan copies as directed herein above. Forfeit.
Number 17.
Please don't. It's a court, it's a high court. Repeatedly, I am saying that don't interfere while proceeding is going on. There are time to make mentions. Everybody will come and make a mention. Is it a decorum of a court? Yes.
In the same FIR, I will take forwarding. I will settle for the complete
You,
another.
It is there.
What
what is the allegation? Pace?
I passing the order by the Islamic system for and the government is my situation also.
You are Mr. Bittu Borua? No.
I am asking. Itu orang baik, kita ni in this case, you take on under. Itu orang itu dia akan proven artikel to execute the draft and two other. And I am the two other.
Let him go. Whether Bittu is already arrested. Okay. When have you arrested? 13. Considering the nature of allegation made, considering the fact that the petitioner is not named in the FIR, inasmuch as another person who purportedly purchases stolen mobile handset has already been granted bail by the Learned Session Judge Kamrup Metro Guwahati, BA number 70 of 2023. First up, the Learned Counsel for the petitioner submits that he is also in a similar position, and considering the period of detention, he may be granted bail, inasmuch as he has thoroughly been interrogated by the police. Considering the nature of allegation as well as the period of detention and the fact that the co-accused similarly situated has already been granted bail, the present bail application stands allowed to the satisfaction of CGM Kamrup Metro. Yeah, order the silence.
18,
Yes, FIR is it? But these are these provisional certificates. All are addict.
Maybe there are some other issues regarding the lending of some money.
All are addict, including him and the informant.
Even for every purchase, something is going to be. Later when you see to look at the revenue is high. Education is there with the figure of the.
All are addict. How many days? Be there for some days. Huh? Again, you will come back. You will come back and purchase those medicines from pharmacy. When you don't have money, even he'll attack the friends. That is the problem. You are an educated person. You have injured your friend. So you counter-attack. Where is your FIR that he attacked you? Is he injured? All injured. Considering the period of detention and stage of investigation, and also fact that nature of injuries are simple and it was a scuffle between two group of it was a scuffle between the petitioner and the informant, and the informant, they are known to each other, and also the fact that both got injured. This court is of the view that no further custodial interrogation is necessary. To the satisfaction of Amrup Metro 2025.
19,
Yes, Hakim and Aram. Three zero two. Is it 302? So fighting will there. What is the material against these two men, Hakim and Aram?
They have attacked.
This is B or AB? How many days? 62 days.
Injury report is there also for minority weapon uses unknown.
Be there for some day. Why don't you file a search sheet in these cases? If materials are available, you have got injury report, you have recorded the statement. Other accused role might be different. Who knows? What you say? That is the allegation. Badly injured on his eyes and made him senseless and left away. As a result, my son is fighting for death at GMC. If that is correct, and they participated a role, 307, so 90 days. What is the offense is registered? Huh? 307 is also not business. Sharp weapon, injury is the vital part of the body, not mentioned. Even if weapon is not mentioned, but if somebody uses vital part of the body. He beat himself. Achha. You give compensation to these people. 2 lakhs each. Because the accused beat himself and got injured and in hospital. They are innocent. You are putting behind them bar for how many days? You pay them 3 lakhs each as compensation and file a charge sheet. They and keep them good food, everything inside there. He beat himself and got so much of injury. Don't argue this kind of thing. Argue something different. Yes, Boga, what you say? Serious allegation. We need with their custodial interaction any further. That is the issue. 1 lakh each. To the satisfaction of special judge? All right. Special judge, why special judge? Huh? What special judge? Huh? Where is the forwarding report? Yes? That may be mistake or what? Huh? It should be CGM. Why is no special act is involved? CGM not.
20,
Why? It is there.
Kedar is the-
Who is your senior?
This one.
he also was a fight between the
Two groups.
two groups, after injury. Both of us after injury, but other one was after injury, my 80% was because start to start open for people injury. Like, you know, this is after injury of injury. So that's not good.
How many days?
63 days.
Huh?
63.
Yeah, but the order to group fight between two groups, 63 days considering period. Today is inspection of?
I know this is
You know nothing.
SDM Hazil somewhere.
I mean, CGM, I mean,
21,
yeah, but both fight between two parties. Huh? Item number? Item number?
21,
Next, this is also Passover. Series there, same incident, same affair. Yes. 366. What is the statement of the drug?
One 164 in the medical.
We have been given less.
Yes.
It's a case of notice, why and not be a mess.
Around 6 months. But they-
Who is inside
they
6 months?
giving the same amount of paper to us, and now it is around 3 months.
Appeal to admit. LCR, admit, LCR, one except also. I think the FOXO would informant is there. Huh? No, so notice to the number two, registered edit. To sub, IA to click off issue notice, same, so. I had disposable. Considering material available on record. And also notice now again, and also consider, or can we grant without hearing the. Okay, so notice, so. Considering the period of detention, period of sentence, as well as material available on record, this court is of the as an interim measure till LCR is received and the respondent number 2 appears as an interim measure, the petitioner be allowed to go on bail on furnishing of bail when of 50,000 to the satisfaction of special POCSO judge Nalwar. I dispose of on him.
Item number 12,
You people should at least brief your junior councils. Say that this is the situation, I am either on previous bail or not on bail. That, how otherwise, how will they run? This is a not a case that will require your presence. That is how they will grow.
You might have to do for that.
No, that understand.
Temporary sales come, but my permanent university suffering from high level.
Okay, they should know that what is what. At least that they should go through the brief. This is the scope. This 145 proceeding, I will. It's like saying I will not say. I do not like at all this 145. Now what is this? Initially status quo granted. It went to the session just says okay stay. That is, this court has given status quo. We are happy. She was happy in between. Now you are happy. Now whose happiness should we go back to the magistrate and leave your evidence? Get your who is in the possession. No, not right title. This is only for possession. And everybody will have the liberty to, if your title is crowded, go to the civil. Is it a case to do before puja? Do you think this is a case should be done before puja?
I could not appear, so lordship takes this matter after 1 month. Today I am for disposal of this matter, otherwise lordship, since 2002 there was a house lordship. He is paying electricity bill lordship. Now while he wants to renovate the house and multi-story building was started, then the problem came lordship. Since 2010, from permission is there, house was constructed, we were deciding whether 145 can be given over a house lordship. For that on last occasion, I have given citation lordship. This proceeding is to be dropped lordship. If any party is agree.
I will not drop. Go to the session judge where we are directing the session judge to complete it within a period of 2 months. Magistrate. No, to the session judge. The revision. Let the revision be decided.
Revision is pending lordship. The same thing they have done.
According to you, until and unless some materials are there, how it can be displayed, effect can be decided. This is it.
Dispute is there, I am also admitting that also. If even if there is any dispute also, that has to be decided by a civil court.
Why don't you file a suit
But
of suit?
they are, they will go to civil court and file and civil court also. I am staying over that property since 2010, also. I have annexed all the documents, my sale deeds and all this I have annexed. Also.
This 140, I really, I do not like it.
Lordship, on last occasion, I have relied on the decision of the Patna High Court. Also. The Dilip Kota case. Also.
Regarding the land also, there is issues. I have signed one reply or where I have shown the power of attorney.
Better to take a, better to hear a 2002 second April and pass a judgment on such situation instead of doing all this.
That also, Lordship, I am playing the court number 17 and 26 sitting civilian contract. Yes, Sahalim civilian contract. Maybe we are Sahalim.
Don't say all this.
There is still lots of papers there, affidavit data, the over says that there is no,
And not today, not today, not today. Give a date.
Lordship, you send it back to the revisional court will decide and then.
court cannot take evidence.
He is having happiness here. You are having happiness in before the sessions court. And this court's happiness will be to wash hands from this case and send it to your trial.
One particular proceeding, when the attachment order was started, we do not challenge that immediately. There is a decision of all high court which says, divisional court returned my decision only because the first interlocutory intermediate order was not challenged by the party. On that ground also, the revision was dismissed by the divisional court. So it is my duty.
Consuming. 9th of October. October.
Maybe it is.
How many bails they will release before this court? 100? 200? By 115 will finish it.
From Thursday or to Thursday.
Ask Musumi.
On Thursday, it is a hearing date.
39 cases. And above all these bails will come.
Before 12,
One. 28. We'll decide that on that day. Interim order pass, I will continue till then.
And the order was also actually 24/5 that it takes in before the civil revision, criminal revision petition was taken. That was completed.
He was smart. He immediately moved and got us
After
status.
this, it was not completed. Motion and then with
I would not have granted him a status quo. I would have dismissed and I would have asked the sessions court to decide.
My only prayer is that they have to take evidence.
find them by issuing of this. The stay attachment order will be in force till 24/5. And the next date was before the revisional course on 24/5.
Okay, on 28 we'll decide. Yes.
And endeavor to make the dispose of this. Of this. 13.
Same.
For hearing, I think 59.
Yes, what is your instruction? This is a case of 1942. And still we do not know what is happening. And there is no cases made out. It's a clear case of crossing. Go to the FIR, page 16. Read and show us any cognizable offenses made out. This is the status report. One FIR, there are nothing. LCR of criminal petition, nothing. Third, Mr. S.P. Roy, learned senior learned counsel assisted by Mr. Okay, so and dispositional public prosecutor. The present application is filed under section 482. Four 482 or something different. Uh, (482) CRPC for quashing Sangsari PS case number 67 of 2013, registered under section 182/406 IPC. Full stop. Mr. Roy submits that a bare reading of the FIR, no cognizable offense is made out. Therefore, the police ought not to have registered the case and ought not to have started the investigation. Mr. Roy further submits that the matter is civil in nature and there is no ingredients of any criminal offense, not to say any offense under section 133, 138 or section 406 IPC. Full stop. On the other hand, the learned additional public prosecutor submits that a case is made out in as much as from the FIR, it seems that the petitioner, while purchasing an agricultural plot of land, file an affidavit during the transfer that the said land shall not be used for non-agricultural purposes. However, the said land has been used for non-agricultural purposes. Full stop. Therefore, an offense under section offense as registered are made out. Full stop. Where is the FIR? Full stop. From the environment made in the made in the FIR, the following allegations can be summarized. That the petitioner is using the scheduled land scheduled in the FIR for non-agricultural purposes. However, next, at the time of seeking NOC for transfer of the aforesaid land, an affidavit was filed to the effect that the scheduled land will be used for agricultural purposes. Full stop. Next, however, such declaration has been violated and accordingly, and land has been used for non-agricultural purposes. In the considered opinion of this court, the aforesaid allegation will not make out any case, prima facie case, even if that aforesaid allegations as read as a whole, no prima facie case is made out to proceed against the petitioner either under section 138 or under section 406, and at best that can be 182, earlier is 182. Full stop. At best, the said allegation can be is civil in nature and at best can be a violation of no objection certificate issued for transfer of the land and transfer on the land, and no criminal action can be attributed in such background, in the aforesaid background of the case. Accordingly, this court also, the record call for also discloses that after filing of the FIR, nothing has proceeded, though no FIR has been, no stay order was passed. Considering the matter in entirety, this court of the view that no case under section so and so are made out as alleged. Accordingly, the present revision criminal petition stands allowed by quashing the impugned FIR dated so and so. Nothing is there. Yes, and this matter is pending since 2013. Over.